Good morning, Mr. Thompson.
Good morning, Chief Justice Ireland, Justice Cowan, Justice Spina, Justice Cordy, Justice Duffley. My name is John Thompson. I represent Joseph Buckman, who is appealing his conviction for first-degree murder in Norfolk Superior Court in September of 1998, and the denial of his motions for new trial, which were brought since then. Pardon me. This was a trial that was pervaded by serious constitutional error, and I wanted to discuss the most consequential of those errors today and argue to the court that the cumulative impact of these errors requires a new trial. The first problem that I want to address is the violation of Mr. Buckman's right to a public trial, which is evidenced by affidavits from his daughter and other members of his family that they were excluded from the courtroom during the jury selection process. The evidence that we presented on that point has not been controverted. That is, there is no evidence to the contrary presented by the Commonwealth.
Why isn't that waived?
It isn't waived because it was raised at the first opportunity that Mr. Buckman had to bring it up.
His family members say they were excluded. They never mentioned this to him or his counsel or anyone else at the time?
They did not. There was no reason, they had no reason to think that there was anything inappropriate with their being excluded, and it was a matter of half a day.
And the lawyer didn't know that it was happening? She had no knowledge of that at all?
We filed her affidavit. She said that she wasn't aware. Of course, she was in the courtroom attending to the business of jury selection and focusing on the jurors and the information that she had in front of her, I would imagine. So there was no one on Mr. Buckman's case who was aware that this had occurred.
The affidavit, however, doesn't contain much detail. It doesn't say that the judge closed the courtroom or ordered anyone out. It doesn't say that the family said that they couldn't stay or that counsel said anything.
It doesn't say any of those things. As a matter of fact, the trial record is completely silent on this issue, Justice Cowan. But
I'm not talking about the trial record. I'm talking about the affidavit.
The affidavit does say that that these 6-7 people were in the courtroom during the motions in limine, which were heard first on that day, and were directed out of the courtroom after the motions in limine had been heard by a court officer. So that's official action that removed them from the courtroom. There was nothing else that day.
They were also on the witness list, is that correct?
I'm sorry?
All of these individuals are on the witness list?
They were on witness lists, yes. That, though, is, I think, something of a red herring, Justice Duffley, because it's clear that they weren't excluded as witnesses. So there's no evidence that they were excluded as witnesses.
It's clear that they weren't, or there's no evidence that
there's
that's
no
the
evidence
reason?
that they were.
Either way, they could have been.
The evidence suggests, well, there's no reason to think that the court officers knew who were on the witness list at that point.
Well, could they have been excluded because they were witnesses?
I think if there had been notice and a hearing, as is required by by Presley and the prior cases, they might have been.
You know, you need notice and a hearing to exclude witnesses, to essentially sequester witnesses at a murder trial? I think,
the sequestration order could have been issued, but that would be a sequestration order ordinarily directs witnesses not to talk to each other, and the purpose of it is to prevent alteration of testimony and the possibility of perjury.
Because they heard what other witnesses said. And if they're in the courtroom, then they hear what other witnesses have said.
That can happen, but that wouldn't occur during the jury selection process. But what is relevant here is that there was no reason to think that there was going to be any kind of contamination, and if that occurred, the testimony of Ms. Bellotti from the Cohen case is very clear on that point. She said, she was asked in the Cohen hearing, aren't there alternatives to excluding witnesses or family members from the courtroom to avoid contamination of the jury? And her answer was, in Norfolk County, we do it by closing the courtroom.
That was many, many years after this trial.
It was years after this trial, but it was her testimony and Officer Sullivan's testimony was that this was a blanket policy that was enforced in the Superior Court in Norfolk County for 25 years.
Does the judge have to accept the affidavit of the witness?
The judge doesn't have to accept the affidavit.
And there's no indication on this record that she affirmatively accepted or credited the statements in the affidavit.
No, there isn't. What there is she assumed their truth for purposes of her ruling, which is which.
Well, she said even if what they say was true.
That's right.
It conflicts, among other things, with her recollection of the way proceedings are conducted in the Norfolk Superior Court.
I don't think that it conflicted with her recollection, Justice Spina. As a matter of fact, her recollection was consistent with Judge Dorchokara's recollection in the Cohen case. That is, what she said was that arrangements would have been made if someone had asked for members of the family and members of the press to be admitted.
But can't we infer from the denial of the motion that the judge did not credit the testimony or did not credit the affidavit of the witness?
I don't think that that would be a fair inference, Justice Spina. I think that what we have here is, say, under the Daniels case, this is clearly a substantial issue, and we have made a substantial showing. Everyone's at a disadvantage from the fact that this occurred more than 10 years ago, but the disadvantage isn't, or the delay is not Mr. Buckman's delay. That is, this was a procedure or a policy that was invisible, and it may be that many judges weren't aware of it, but it was something that was not brought to the defendant's attention, and that one of the reasons that the...
I'm sorry, what was not brought to his attention? That his family was excluded? This was not brought to his attention? He didn't know his family wasn't in the courtroom?
He didn't know that he had a right to have the public in the courtroom during the jury selection.
Does he have to know he has that right? I mean, he knew they weren't there.
He has to know that in order to waive the right.
Well, are you sure about that?
I think that the Edward case and this court's cases, including Williams, do say that. And I think that the structure of the rule, or of the set of rulings that the Supreme Court has issued, requires that. That is, the public cannot be excluded from the courtroom without notice and without an opportunity for the involved parties to be heard. That's fundamental, and that sets the framework for a waiver. That is, a waiver cannot occur without notice and an opportunity to be heard, unless in some other way the defendant has actual notice.
If defense counsel knows that the family is excluded, maybe the defense counsel doesn't know that that's a problem, but if defense counsel knows the family is excluded and doesn't object at a time when it can be readily corrected, that's not a waiver?
If defense counsel knows, but defense counsel didn't know. That is, even in Cohen, when the court talks about waiver, the premise, the predicate for a waiver is knowledge on the defendant's part, which would include defense counsel. There's no evidence.
Of exclusion? Knowledge of exclusion?
Yes.
Not knowledge of what the law is, but knowledge of exclusion.
That's right. But for the defendant's waiver, it would include knowledge of his right. That is, a Johnson versus Zerbst kind of waiver, a personal, a voluntary relinquishment of a known right is the kind of waiver that has to be found here. There isn't any evidence that would support that kind of a waiver here. I'd like to also address the problem of the exclusion of Mr. Buckman's principal defense by means of a motion in limine. Mr. Buckman's primary defense was that John Loder murdered Susan Buckman. And the day before the trial began, the judge ruled on the Commonwealth's motion in limine that he could not present that defense.
And what does that mean exactly? What was he not permitted to do that, in fact, he was able to do in terms of presenting evidence?
In terms of presenting evidence, he wasn't able to cross-examine Loder as if Loder were a suspect or the accused.
He wasn't?
He was not.
What does that mean? He wasn't able to ask, didn't you do it?
He was not. He wasn't even able to ask whether he had had a confrontation with Mrs. Buckman in the house before the killing occurred. The judge...
I haven't read the transcript, so he was not permitted to ask the question about having had a prior confrontation.
That's right. After the motion in limine, the judge said, you may not argue in your opening, you may not present John Loader, the defense that John Loader was the killer. John Loader was the Commonwealth's first witness. During the cross-examination, the Commonwealth objected to questioning by defense counsel invoking the motion in limine order, and the judge upheld it. The judge allowed a few questions and said, don't intend to do very much with this.
But didn't defense counsel in the opening statement suggest, nevertheless, that Loader was the culprit by saying all the time, supposedly he did this and supposedly he did that?
She did.
So she cast
Make
aspersions on
She
him.
cast aspersions on him. She inferred she did the best that she could, but she was hamstrung by this motion in limine ruling. This is an abuse of a motion in limine, and a motion in limine is directed at specific items of evidence. This was a motion in limine to preclude a defense, and it was ruled on the basis of counsel's representations, not on the basis of evidence heard or evidence presented. The most serious handicap, though, was in the closing argument. Specifically, the judge said, you may not argue that John Loader committed this murder. Nobody argued the facts that were available. That is, John Loader was there, was at the house, the scene of the crime, at about the time, according to the medical examiner, that Mrs. Buckman died. 5:53 in the morning, according to the medical examiner, was the time of death. Loader said he got there about 5:50 in the morning. So there were two people, there were two men in that house. One was John Loader, and one was Joseph Buckman. According to Loader, Buckman was unconscious, bound, and gagged in the basement, in the garage, at the time he arrived. He wasn't restrained. He was wearing a step-in coverall. The garage was a place where he worked. He had two knives that he kept in the garage where he worked. One of those knives was missing. It was never even looked for. Okay?
And none of this was brought out in the examination of the witnesses?
Some of it was brought out willy-nilly, but
And
none
some
of it was
brought out, and some of it was brought out in closing argument. A great deal of it was brought out in closing argument.
Much of it was brought out in closing argument, but was only allowed to be cast as a Bowden argument. That is, as the court noted and pointed out in Silva Santiago, there are two separate defenses that are closely related, frequently closely related. One is the police didn't do a good job. They didn't get the right person. The other is somebody else did it, and in this case, it wasn't just a vague someone out there did it. It was this person, this other guy, John Loader, who was there, who had weapons available to him. He had the opportunity and the means, and behaved suspiciously, and had possible motive. All of that was available, but it wasn't allowed to be presented. The lawyer's job, the defendant's right to present a defense, is not just the right to try to scatter facts across the record and insinuate that there might be something there. The defendant is entitled to present a full defense. Includes an opening statement. An opening statement is very important. That sets the story for both parties. Juries accept story. They look for a storyline. They look for a coherent storyline, not insinuations. They look for, you're entitled to make an opening statement because you want to be able to tell the jury what to look for in the evidence and what the significance of it might be. Then you should be allowed to present it directly. When the suspect, the alternative suspect, is on the witness stand as the Commonwealth's first witness, he's protected from effective cross-examination by the order. The defense lawyer is handicapped by the fact that she's constantly trying to figure out what she can do without violating the judge's instructions. So she can't go after, and she wasn't allowed to go after John Loader. She wasn't allowed to challenge his alibi, which was never investigated. His only alibi was that he left home
What's
in the morning.
the judge's logic in allowing the motion in limine?
His argument was that his ruling was that the evidence that was presented, and I have to concede that defense counsel's presentation on this was scattered. It was not focused. It was not particularly good. But his ruling was that she hadn't made a sufficient offer of proof to show that she would have be entitled to present that defense.
So you,
Does a lawyer have to make a sufficient showing?
Well, you do. The defense does in order to present a defense, but the ordinary way of doing that, the due process way of doing that, is by presenting evidence, and then at the conclusion of the case, when the jury instructions are given, the question comes up: does the defense evidence support the instruction or support the argument that the defense wants to make? Here, the ruling was, you can't put in the evidence.
you concede, however, that the proffer that the defense counsel made to the judge was rather weak and not as direct as it might have been. So based, we have not read the record, but based perhaps on what she said, the judge was correct in ruling that there wasn't a sufficient foundation to present third-party culprit evidence. If so, then we would have to reach the question whether there's been a substantial likelihood of a miscarriage of justice.
Yes.
And the defense was able to present a great deal of evidence suggesting that Loader was there with improper motives.
Well, I would suggest, Justice Cowan, that this is a preserved issue. That is, she made her best argument. She objected to not being allowed to make the arguments. She objected to not being allowed to cross-examine. She objected to not being allowed to close.
But I understand that. But if the judge is not given sufficient grounds on which to on which to deny the Commonwealth's motion, then you wonder how one can fault the judge.
Well, the motion itself was improper, Justice Cowan. I referred in my brief to Justice Greeny's ruling in O'Malley when he was on the appeals court, which this court recently referred to approvingly in Madigan, the Madigan case. And what Justice Greeny was very clear in saying that it is improper to disqualify a defense on a motion in limine. That's not what motion in limines are for. That's like directing a verdict against the defendant. It deprives the defendant of his right to counsel and his right to present a defense.
Well, but as the evidence unfolded in this case, could counsel have revisited the motion in limine and said, "Look, now I have established a foundation, and I would like to be able to argue that Loader was a third-party culprit"?
She could have done that, and she
did.
did.
Evidence, in fact, unfold in such a way that would have enabled her to make a good argument?
Certainly, by the time of closing, she had some of that evidence in, not in an organized way, the way you would present a defense, but it was there. And at the conference in Volume 6, about page 125, at the conference on what was going to be argued, she said that she wanted to argue this defense, and the judge said, "You can't," and she objected. So I think she did an adequate job of protecting the record. It was clear what she was trying to do. The judge knew the impact of the orders, but one of the impacts was she wasn't able to develop the evidence adequately because this was precluded from the beginning. This is what's wrong with using a motion in limine in this way. Did
the judge say in the ruling on the motion in limine, there is no conceivable way that you can ever present this defense, which happens to be a recognized defense, or did the judge say you haven't presented enough evidence to me at this point in time to be able to argue that?
I don't think it's fair to say that the judge left it open, but when she made the effort to put in the evidence, she was, that is, by cross-examining Loader, the first witness, the judge said, don't intend to do much in this direction. She asked a couple of questions and dropped it. So
you're saying to us that when we read the transcript, we should be satisfied that this judge essentially imposed a complete ban on the use of third-party culprit as a defense?
I wouldn't say a complete ban. I would say he significantly handicapped counsel and let her know that this was not what she was not going to be allowed to do this, and she wasn't allowed to argue it.
No, I'm very sorry, but your time is up.
Thank you. I appreciate the time, and I ask the court also to look at the false evidence issue, which is very important.
Thank you.
Good morning, Your Honors. Varsha Kukafka for the Commonwealth. There are 3 reasons that the closed courtroom claim fails. The first is that there is nothing in the contemporaneous record. The second is that all 7 people who were allegedly kept out of the courtroom were on the witness list read to the jury, and that the evidence that there was a sequestration order is at pages 78 to 80 of the pretrial, the day of pretrial, the day before Volume 1, where the judge said that he would defer on exempting anyone from the sequestration when the prosecutor had asked that the victim's sister and brother-in-law could be exempt. The judge and the defense counsel said, no, I'm going to call them. The judge said it's unfortunate sometimes when people are kept out of the trial when they're not actually going to be called, even though their name was on the list. And when she said, I'm going to call them, the judge said, then I'll have to revisit this. And
Did the judge use that as a reason in deciding the motion for new trial?
I'm sorry.
Did the judge use the existence of a sequestration order in the reasoning?
No, Judge Fabricant did not. I'm also pointing to one other place in the record, Volume 4, page 98 to 99, where defense counsel says, because of the sequestration order, the family members have been outside the courtroom. And this was prior to the defendant's children taking the Fifth Amendment and Trooper Metaliano testifying about his conversation with one of them about football betting cards.
What was the record site?
The record site is Volume 4, page 98 to 99, where defense counsel is asking that the sequestration order not be observed at that point. The third reason that and in Cohen, footnote 10, this court said that one of the people who said they were excluded from the Cohen jury selection was on the witness list, and therefore they would have been sequestered. So that seems to answer that question. The third reason the claim fails is that this court has already said in Commonwealth versus Grenadier, has rejected that there was some kind of blanket policy at Norfolk Superior Court excluding people from jury selection. And certainly that was the case here, and the defendant's proffer was simply, it wasn't even used for impeachment, it was simply putting forth the former court officer Larry Sullivan's testimony in Cohen, where in this case, it was a different lobby court officer in the first place. It was Steve Minkowski, who happened to be a lobby officer in Grenadier, and he testified in Grenadier that he did not hang up a sign that the courtroom is closed. So for those 3 reasons alone, this claim fails. As for the third-party culprit, there is at pages, Volume 2, page 59 to 66, trial counsel did ask John Loder, did ask him about did confront him about a supposed confrontation. She was allowed to ask him, didn't the victim not want you in the house? Didn't the victim find you in the stairway on your hands and knees, and you said you were playing with the cat? So the fact that the questions ended at that point was simply he answered no. So she was not foreclosed, and everything in the defendant's reply.
Excuse me, again, we have not read the record yet. Did she ask questions and there were objections and the objections were sustained in this vein? Ask questions in this vein?
There was an objection, and the judge said, I'm going to give her a little leeway, and she was allowed to ask the question that I just said.
And then at the end of those questions, was there another question that was, and an objection that was sustained or not?
I think that it ended when he said, no, I didn't. I was not told not to come in the house. I was not found in there. There was no confrontation where I said I was playing with the cat. Everything in the defendant's reply brief in footnote 11, where he says was not allowed to get this evidence in, virtually all of it was in. And it came in strongly from the beginning, as I have in my brief, citing as many through opening statement, through cross-examination of Loader, through cross-examination of some other witnesses about you didn't send anyone else's blood to Cellmark,
But she wasn't able to argue it in closing argument.
well, she certainly argued who else had the keys to the house. I mean, a lot of things.
All right, well, let's say the judge permitted the defense, third-party culprit defense, evidence and argument. What would have happened differently?
If he had permitted it rather than permitted it as a inadequate police investigation.
Correct. Would she have been able to argue differently?
I don't really see that there would be that much more because there really wasn't that much more evidence. I mean,
Well, is it just the question of saying, we know who did it? We know who did it. This is the person.
I
John Loader
suggest
did it.
she went up to that line of saying, John Loader with a criminal record, he's the one. He knew there was cash in the house. He knew about the football cards. He was there that day. So it's really, she got just about to that point. And I don't think anything more would have been gained. It might have looked worse to say that he
So by
did
the
it.
end of the case, why was the judge's order still appropriate?
Well, there hadn't been any showing that there were substantial links with John Loader. It didn't meet.
How could there have been a showing if the judge didn't permit her to make it?
She has to make it at some point. She didn't make it in her proffer, and she didn't make it in any other way. She didn't show. I mean, she even, if one of the key things is that the victim was afraid of John Loader, if that was admissible as hearsay, she asked the defendant's daughter about that issue, and the defendant's daughter took the Fifth Amendment even on that question. So how would she show it? This is not like Commonwealth versus Conkey, where a tenant testified as to what that landlord did, and that landlord's girlfriend testified, and his fiance, and there were all these people coming forward.
So she was permitted to ask the defendant's daughter if the victim were afraid of Loader?
She did ask that during the questions where she took the Fifth Amendment to each and every question, and she took it to that question. So plus, she was not a witness to that. It would simply have been hearsay as far as
If that were admissible
if
anyway.
it was even admissible. The issue of third party, I guess, weaves into, although defense counsel did not discuss the issue of the faint results, I would like to point out that from the very beginning in opening statement, trial counsel was talking about there's someone else's DNA there. And she cross-examined Sergeant Flaherty. This is before the objectionable testimony by Leanne Hooper. She asked Sergeant Flaherty about someone else's DNA. And then, this is even more key, the witness before Leanne Hooper, Paula Yates, who was a Cellmark analyst, was asked about whether there was other DNA, other results. So this was all leading toward, not only was the defense that it was an inadequate police investigation at every turn in terms of not testing fingernails, not testing the knife, that this particular DNA, there were some items that gave faint results. And so at that point, the prosecutor was entitled under Matthews to elicit that there were inconclusive faint results, which may or may not have even been real DNA. And the trial counsel continued this throughout cross-examination of Hooper. She said again that the victim was excluded. Yes, so that was out there. There was no question about that. She asked her, aren't there many items that have that diamond symbol, which means it could be a technical artifact, it could be someone else's DNA. She pushed this all the way through. She asked again, Robin Cotton about the faint results. So the issue of the faint results, which is really just inconclusive evidence, and it does not look like there was an orchestrated plan, because when the prosecutor asked, well, were there any other results, she said no. She said, there were no other conclusions. So it was just an inconclusive thing. There was no objection either. And the defense closing, again, was that someone else's DNA was on the defendant's shirt. And so the trial counsel took full advantage of this. Now on appeal, the issue, and which shows a very good reason why she didn't object when the prosecutor asked about the faint results on the tape. The issue as to exactly which piece of tape that came from, I know that came up in my brief and in the reply brief. Our view is that it was part of the tape over the defendant's mouth, but it really doesn't matter, because all of the pieces of tape, his fingerprint was on the tape, and whether it came from that roll of tape that was inside the bedroom, that tape was opened up a couple of inches to get that print and that blood sample. So realistically, that's the defendant's mark was on there. And as far as closing argument, Justice Fabricant made a very reasonable ruling on this, is that where the defendant did object to the faint results only in closing argument, is that it went beyond what Hooper said. Yes, it did, but in the context of the entire case, where the defendant's blood was on those fingerprints was on those tape, and the victim's blood was all over his clothing, in the size of 1 millimeter, which is there at the forceful event. It was definitely fair argument at that point, and the objection was rather weak in any case. The other issues, I would rest on my brief, and if there are no other questions from the court, I'd ask this court to affirm the first-degree murder conviction.
Thank you, counsel.
Thank you, Your Honor.